Welcome back and thanks for staying with us. It's Rapid Done right here on Rapid TV, and this is the 9 o'clock hour, top of the hour to you. I hope you've been having a good morning so far, and I hope we've been able to stay true to keeping you informed, educated, a little bit of entertained for this morning.
Of course, something that actually made me smile a little bit more was when Victor Ejema had to reiterate the fact that Arsenal FC won our game yesterday.
Whatever, you guys. Are we back here?
Yes, we're back here. So.
But I'm proud of you guys. So I'm really proud of you guys. You're making progress.
Now you're talking.
From the start, I was like, don't make too much noise so you don't jinx it.
No, but our fingers are still crossed anyways. Until we see a cup on this table, then we know that there's something for us. We've been doing good.
The siege has been broken.
Yes, it's gonna
when
be
there's a cup. All right. Like we stated from the start of the hour today, we will be having conversations centered around Nnamdi Kanu. Once again, his conversation is taking center stage in Nigerians' national discourse. Last week's judgment, complex, layered, and immediately contested, has opened debates and has sparked public conversation for nearly a decade. And today, across the country, emotions are high, which is one thing I communicated with the guest yesterday, saying, you know what, it's a very sensitive conversation, and there are lots of interpretations to these conversations, and the implications are far-reaching. Now, since Kanu's first arrest in 2015, his trial has evolved from a strictly legal matter into a defining case for Nigeria's rule of law. Some say that it has become more of a political matter than it is a matter about the law, about national cohesion and the future of the Southeast. From the 2017 bail and detentions that followed, Operation Python Dance, to the controversial 2021 extraordinary rendition from Kenya, and now this latest court ruling. Each stage has raised questions, not just about justice, but about governance, security, human rights, and the moral authority of the state, seeing exactly how he was repatriated from, Kenya into Nigeria. Now, for the Southeast, the conversation is even more personal. Reports suggest that between 2020 and 2023, the region recorded hundreds of violent incidents linked to separate tensions and economic losses running into, the trillions as a result of the periodic sit-at-home orders. Now, when a new judgment emerges, it is not merely a legal update. It's a trigger for hope for some, frustration for others, and deep concern for many. But today, we are asking the questions that matter. What does this judgment really mean? Where does it leave Nigeria's justice system? What are the implications for security, for politics, and for the everyday people caught up in the middle? And most importantly, what is the path towards a peaceful and lasting resolution? Now, today, to join me on this conversation, or to join us on this conversation, is one who seems interested in the topic. We have with us today Ibrahim Usman Wale. Good morning to you.
Good morning, Ms. Martha. It's my pleasure joining you. You already said that it seems...
See the way he's smiling. Okay.
Yeah. I mean, you already said that, the polity is tensed up because of the judgment. So I think it is very important that we render a little bit more dispassionate, analysis of the situation. So it's my pleasure to join you this morning, and I really pray Arsenal bottles it at the end of the day.
So you joined them from law to football. Interesting. All right, let's get into the crux of the matter. Now, what legal, from the legal angle, what exactly were the key elements of this judgment that has made it have a lot of conflicting interpretations? In fact, if I am to count the number of interpretations I've had on that case from Friday when the judgment was passed to today, I can say I'm confused, because this party says he did this, that party said he did that. But just let's know, what are the key elements of this judgment that has made it have so many conflicting interpretations?
Thank you so much for that introductory question. The reality is, as much as this judgment is highly contested and is kind of controversial, the reality is most judgments really for parties involved suffer these interpretative differences, and that is why I believe in the hierarchy of our courts to see that even the Constitution recognizes that after the first court decides a matter, you can go on appeal, you can go to the Court of Appeal, and then you can go to the Supreme Court. And this is because they also obviously know that the court might have or might not have, missed something. So the different interpretations I believe is as part of the process. But it's important at least that we understand what the legal parameters of the case are. Because regardless of what you think about the exigent issues around the case, it is what is brought before the court that is going to end up forming, part of the final judgment. So anything that is outside of that may or may not form, part of the judgment. So he was brought before the court on a 7-count charge after the history that you have already told us regarding this case. It was a protracted case. The first count was on terrorism. It was on his broadcast where he said that people will die, right? So this is the count, the evidence were put forth to support the count, but this is just the allegation itself, that, you made a broadcast and you said people are going to die. Secondly, it had to do with the sit-at-home that has been going on in the East for a very long time, and I'm very certain, we all know the implications, of the sit-at-home. So that was the second count. The third count was with regards to the indigenous people of Biafra. You know that the court has already proscribed them as a terrorist group. So in his statements as well, they claimed that, or the allegation was that he claims to be a member and in fact the leader of the IPOP. So that in itself is a single count. And then in the same broadcast, or there are a lot of broadcasts, there was another allegation that he directed people to kill Nigerian personnel and their families and Nigerian officials. Right, that is the security officials, Nigerian police, and Nigerian army. So that in itself is also a count. And then there was a count that said that he incited the people to make bombs, right, to make explosives and to use explosives. And then the last count was that he imported using household items, radio transmitters, illegal radio transmitters, which he used to broadcast, all of those things, and the transmitters were actually put forth before the court. So these are the charges, these are the counts. This is before the court. These 7 counts that I've just enumerated. Now, there is what is known as a procedural aspect of law, and then there is a substantive aspect of law. So, on the procedural aspect, the defendant, Nnamdi Kanu, decided to file some applications, some motions, challenging the jurisdiction of the court itself. That is, before we go into the counts and the evidence and how the court analyzed it, he put forth these applications. So the first one was that he was denied fair hearing. So he claimed that he wasn't given fair hearing, the time, the facility to make his case. He claimed that, he didn't have access to his counsel most of the time while in DSS facility. He needed some information and they didn't give him the information. And even in court, he claimed that he wanted to make some points and he was not allowed to make some points. But the court disagreed with him. The court said that you were given ample time to do your case. Even I pleaded with you to enter your defense and you didn't enter your defense. Now, the rule on fair hearing is that it must be guaranteed, it must be given. But if you decide not to take it, then it must be given and it must be seen to be given. Was it given? Well, that is what the court said, that he was given, right to fair hearing. He had legal counsel. The court referenced the fact that he, dismissed, some senior counsel who represented him, and that, he did refuse to put up his defense. And I remember when the court adjourned the matter to, for him to put up his defense, and then he didn't put up his defense. So, the court decided that you were given ample, fair hearing, and you did not take it. So that preliminary objection was quashed. He then argued that his illegal rendition of 2021 ought to seize the court of its jurisdiction to try the matter. Which
was in court. And I think the matter was quashed out of court one time because of that.
So what had happened was when he was, illegally renditioned back to Nigeria, he challenged the matter in court. When he challenged the matter in court, at the Court of Appeal, he got judgment in his favor, saying that the rendition was illegal and therefore the charge is not going to stick. But the government appealed to the Supreme Court. And the Supreme Court decided that, well, while it was illegal indeed, but it does not obviate, it does not take care of the charge sheets before the court.
But what does the law say about that?
The Evidence Act speaks about this. It says that evidence that is obtained through illegal means or unlawful means generally are inadmissible. So this applies to, defendants as well, but there are exceptions. There are exceptions
that means it,
in
okay.
the law.
Okay.
The law, at least, is very important. There are exceptions in the law where it is absolutely necessary, where you have tried every other means and that is the only means available for you.
Okay. Okay.
Then the law allows. So it's not. It's the law is try to be very careful, and cautious. But in that instance, the law allows it. And the Federal High Court Justice Omotosho, he cited the Supreme Court judgment, and then he cited the care-frisbee concept. It's an American concept that analyzes situations of illegally obtained evidence and illegally brought defendants. So that's the thing with the law. Frankly, there's always exceptions here and there. So the general rule is that ordinarily it should be inadmissible ordinarily, but then the court disagreed. So that's that on that. He then argued that the law that he is being charged under, that is the Terrorism Act, was repealed, repealed in 2022, and that they are charging him under the wrong law of 2013.
Yeah.
Okay.
There's a new law, repealed 2022, but his charges were under the 2013 law. So he argued that those,
were passed.
Yes. So, and the law is that, where you are charged under a wrong law, then, it's quashed. But the court again said that the events in the charge happened between 2017-18 to 2021 before the law was repealed. But then it even went on to cite Section 75 of the new law, which had a savings clause that said that if there are proceedings lingering or pending under the previous law, this new law is not going to affect it.
Okay.
Yeah, so this is how the court decided the preliminary objections. So I don't know if we should go straight into the crux of the substance.
Definitely, we're getting there.
We'll get
we're
there.
getting there.
Well, let's jump to it anyways now, because we saw that Justice Omotosho mentions that all of the counts that were against Nnamdi Kanu would have led to a death penalty. But he decided to go for life imprisonment, citing religious views and all of that. How do you assess that particular conviction?
Yes, well, it's difficult to assess the conviction without looking at the analysis and the evaluation that leads to the conviction. You can't, justify or disagree with his position if you don't look at, what led to it. So I'll have to take us back a little bit. So the State Security Services, the DSS, although it was a Leonard Silk, our lawyer saying, very refined, very, cerebral, who prosecuted the case, I think they put in 5 defendants before the court, all of which were DSS officers, or rather, government officials, and about 30 exhibits. The transmitters, a lot of recordings, his own statements, statements of his supporters or members of IPOB, and also there was a barrage of evidence. So the court initially, because Nnamdi Kanu failed to present, a defense, held that action led to him resting his case on that of the prosecution. And that is a very, very dangerous defense strategy to take. You only take that strategy. I don't know if it was a strategy for him or a protest, but you only take that strategy if you are dead sure, if you are confident that the prosecution did not present any evidence whatsoever. But he filed a no-case submission that was overruled. And that should have informed him that, the prosecution, they do have a case, because a no-case submission simply means they've put forth their evidence, their argument, and they don't have a case, strike it out. But the court looked at it and said, oh, they do have a case, you have something to answer. So resting the case on that is...
It's like giving...
yes, so I don't know if it was a strategy or a protest.
Okay.
Yes. So the court now held that, so this means that naturally, if the evidence that the state has put forth is credible, then it means that, you deem it, it
regardless
means
of how it was obtained, because I think that this is where the confusion is, or this is where the disparaging views and thoughts on this judgment is, because we have clearly established that some of the ways that the government was able to obtain what it now calls exhibit or evidence was illegal, and they went to the court, they appealed. You have clearly stated the judgment. Do you think that... Okay, go on, let's hear it.
The appeal has to do with his own personal rendition. most of the evidence were not contested on the ground of, because most of them were recordings that, you can just download online. But like the transmitter, for example, I think it was when they went to his house and, so for the transmitter, for example, you could, maybe it's arguable. But most of the evidence, there was no contest with regards to how they were obtained. It was his own personal rendition that was an issue. So resting your case means that, the court has no choice but to give probative value to the evidence before it. So now the court now went into the evidence. Obviously, the broadcast was the, really major evidence, and they were not able to get it struck out during the, I don't know if they, but it was admitted into evidence, so the court has no choice but to actually look into it and rely on it. So it's, for count one, for example, indeed there was a recording where he said that people should die or people will die. There's no doubt about that, right? Obviously, he proclaimed that he is the leader of IPOB and is a member of IPOB than itself. So that was it proved itself, and the court gave him 7 years for that, being part of that. But for the first one, the court gave him life imprisonment. Now, for the second charge, sit at home, the court also brought a lot of evidence that it wasn't just, sit at home. It wasn't just a protest, but that there was consequences that followed your refusal to sit at home. So that was the distinction. Yes, you can tell the people to sit at home as a protest, because the court tried to ensure that your right to advocate for self-determination is protected. You have it, but immediately it carries the elements of fear and the threat, and in fact the reality of seeing through that threat to actually punish people who failed. That's terrorism. So the court held that it's terrorism, and he gave him life imprisonment on that as well. For the fourth count that had to do with kill the officials, kill the personnel, they brought quite a lot of evidence.
So it's actually
bomb
carried
police
out.
station, bomb. So they did all of these things. Although, in my own legal, understanding of that particular count, because some of the evidence that the court used, for example, were statements and, broadcasts of a certain Onye army, right? So I felt like if you're not bringing Onye army to testify in court himself, I don't think you should loosely rely on his statements and say that there's a causal link between his statement and what Nnamdi Kanu said or what Nnamdi Kanu incited. So to that extent, I maybe disagree with that position of the. And the court also went ahead to say that during the NSAS protest, he also made publications about the need to bomb this and bomb that and kill this and kill that, and they referenced the destructions in some parts of the southwest, Lagos, for example, ERC buses. They mentioned a lot of those things, and Ahmed Bulak's killing, Bulak was killed, yes, so they said, okay, these were all results of his incitement, because incitement is one of the counts, so you incite, the public to, disorder.
But can that be contested as well?
I'm going to get to that when we talk about solutions, right? Like I'm looking at it and I'm looking at grounds of appeal, and we're going to get to that. So I contest that as well, to be frank, because I don't think that there was a direct causal link between Nnamdi Kanu's, statements and what happened in the Southwest or what happened with NSAS. I don't agree with that position at all. I think what happened in NSAS was documented. The thugs who were attacked, who were destroyed. We had pictures of that guy with cutlass that has not been prosecuted. So none of them, at least bring. If you arrest some of the so-called destructors and they come and say this is who directed us.
Exactly.
So I think one of my problems with the evidence entirely is the fact that only the state security service were literally witnesses in the case. I felt like victims should come out, even the sit at home, for example. People who lost their businesses, people who lost their lives, people who could not go back to their homes. They should come and testify. It adds a lot more credibility to the case, but just the state and its evidence
and concludes on the matter like that.
Yes, but if you had allowed the Leonard Silk's chief Kanu Agabi and
That's going to be the next question.
If he had allowed them to do their case, I'm very confident that this, at least, he wouldn't get a life imprisonment, even if he gets. I am very, very good. These are the finest lawyers in Nigeria.
They are the finest lawyers. Everyone keeps saying that these are the finest lawyers, but these same lawyers that you claim are the finest lawyers have left him there.
It's not a claim.
It's okay.
It's facts.
These lawyers that is claimed to be the best lawyers, you know, have had him. He's been in custody for a very long time. The matter has lingered for a very long time, and therefore I knew that emotions were bound to be heightened in this case, especially because you're out there, you say you are the finest lawyers, you should have gotten me a fair hearing.
They're not saying it themselves, we are saying it.
We say, okay, so and I'm guessing that that's based on that.
Yeah, but this is regarding evidence regarding.
Listen, when I say somebody is the best in something, I need to have experienced it for myself, regardless of what everyone says. My experience with what that person is able to deliver is what makes me reiterate the claim. So if I haven't experienced it, it's still a claim.
I think there's a misunderstanding as to the role of defense counsels. Your role is not to come and concoct evidence, or to, your role is to
not to concoct evidence,
so
right?
It's not to do magic. It's, you know, instances where maybe there's potential death sentence, you get a life imprisonment, there's a life imprisonment. There's the variables. It's not about win or lose. That is not, we want justice at the end of the day.
Okay, so but the matter has not significantly.
It's very important to also mention that this fine gentleman, I've not been involved in the case from the inception. He has had his lawyer, Mr. Aloy Ejimako, and, you know, fine lawyers in their own rights. But it's not as if these were the guys. If they were the guys from day one, I'm telling you, he would have made a difference.
So he made the wrong choice.
100%. Maybe as we're saying, I mean, maybe I'm sentimental, but this is literally, this is Chief Kanu we were talking about. This is why I love law, because of people like this. You know, if they were not practicing, it wouldn't have meaning for me.
Let's get on to this very question, because we have said, no, they are the finest lawyers. Yeah. They are the finest lawyers. They try what they can and what have you. But from the analysis of the case, from different lawyers as well and legal practitioners, one of the major concerns they've been able to raise was the fact that he was very unruly in court, and he kept, many times you'd see the videos where he kept shouting at the judge. He kept talking about. So I wanted to know what the place of that was in the court, because can you make a judgment on a person based on that? Because that's more of an emotional matter than a legal matter. I just want to understand that perspective of that conversation.
What is the thing with law, right? Law really allows for a lot of dynamics. I mean, if we go into jurisprudence, which is, you know, quite a lot, you would find that there are schools of thought that, you know, consider, you know, the entire mindset of a court. But even, you know, under evidence law, you know, the conduct and demeanor of a defendant is important in the evaluation and assessment of the court. This is law. This is not emotion. The court, a trial court, you know, adjudicating on a criminal charge must, you know, pay attention to the demeanor and conduct of the defendant, because it forms part of the entire, you know, the court is supposed to look at the entire gamut of the process. So I don't think he helped himself with that. Even if you disagree with a judge, you disagree with a court order or anything, you know, you still have a duty to respect the, you know, the institution itself, and to, you know, at least give it the benefit of doubt. There are established way to challenge all of those challenges. There are established way to put them forth. You know, so those acts did not help him at all. And if it agitated the mind of the judge wouldn't have been wrong to, at least if that is not what is, you know, the fundamental or substantive reason. But, you know, if after looking at the facts, the judge is now, you know, looking at whether he was remorseful, you know, whether he was compliant, then the answer was negative. So it adds to it, and judges are humans at the end of the day. Yes. So.
All right, so after the conviction, the court actually ordered that Nnamdi Kanu be placed in a protective custody, and decided the reason, of course, for security reasons as it is. What is the legal justification for this kind of protective custody in this scenario?
Yeah, so it's the discretion of the court. The correctional facilities have their own manuals and order, but it is the discretion of the court to decide, you know, the custodial condition of a defendant, right? So if they feel like he's not going to, maybe he's going to be a potential, I don't know the court's reasoning, a potential danger to other inmates in, for example, Kuje. I don't see how that would be different in Sokoto or Katsina anyway. But personally, I feel like, the court ought to have allowed him to
remain
in
where
Kuje.
he was, because
yes, I frequent Kuje a lot, and but like I said, it is the court's evaluation, the court's assessment of the situation. If the court felt like it was too, dangerous to stay in a facility that had literally everybody and had there's ease of access, but all the same, regardless of the facility that he's in, the same rights that is applicable in Kuje should be applicable to him. Right, so he deserves, because prisoners have certain rights with regards to the condition of their, so it has to be habitable, it has to be, humane and stuff like that. So, but yeah, it's the discretion of the court, and we can only really look at it sentimentally, but by law,
it's right. All right. Do you foresee a spike in the reduction of violent activities in the Southeast following this new judgment? And what indicators are you watching out for? Because if you have claimed that such a man is the reason that all of this violence is taking place in the Southeast.
I didn't make that claim.
No, if not you, I'm saying, like, if the law had claimed that this is the reason that there's so much unrest in the Southeast, now we have brought the matter to rest, we have prosecuted. Do you think that this is going to, because as we speak, the sit at home is still going to happen today? This is Monday. It's still going to happen today. And if you claim that this person is the reason, not you again, the legal whatever, if they claim that this is the reason that this has been happening in the Southeast, do you foresee a change in the spike of violent activities around there?
Now, this is a decision against one man, right? And I think that what they tried to do was, similar to the RICO type of law. I felt like, they should have been, consecutive charges of actual foot soldiers, right? Actual foot soldiers, right? Really on ground. But outside of convicting Nnamdi, whether he's on the streets, whether he's out there, if the ambition, I guess, because look at Simon Ekpa, for example. He took over in a way.
That one got
right?
6 years.
It got 6 years, right? So
someone who had
me wanted to so the thing with movements like this is they rarely die. That's just reality. I mean, look at Boko Haram, for example. We thought Sheikha, with his death, but somebody took over. And it's like the mafia. It's like government, frankly. As long as the root causes are present, as long as, the solution is not holistic, then, somebody would spring forward.
So you think that that's going to happen in the Southeast?
I mean, you said yourself that the sit-at-home order was still active. It's still active. I didn't even know that it was still active. I actually thought that, the people had, so. Yeah, but I don't think that would necessarily
change that.
That would necessarily increase the spike of violence in the Southeast. I mean, if it would have already. I mean, immediately the judgment was read, so I don't think that is the case, to be frank. And I think when it comes to insecurity generally, and this is outside of the case, maybe, we tend to mischaracterize a lot of times, our security issues. There may be, real criminals that are really unconnected to him, right? That it's possible that there are criminals that are unconnected to him, and they'll carry out their actions, and they might even carry out their actions in in the name of protest, in the civil. But I feel like the best course of action for him is to trust the process, appoint serious lawyers, and I don't know if any senior lawyer would want to take the case now considering but put forth your case at the Court of Appeal. I want to see, because the Court of Appeal and the Supreme Court, this is the policy court, so I really want to see how they deal with the issues.
Is there still hope for Nnamdi Kanu?
I feel like there is a hope for remission, from maybe life imprisonment to maybe 25, 20 or 15. I believe that there is a possibility for that. And
there's no way that he can be actually taken out of prison, even after he pleads, basically.
I don't think he can walk freely.
That is what is known as a bail pending appeal. But I mean, these are capital offenses. Even at the trial court, you will not get that, not even for bail pending appeal. But with regards to the general insecurity issues, I think that, we still haven't done the necessary work to say confidently that, okay, this thing is in the past. It's unfortunate because the Southeast is a serious business hub, and taking Mondays off.
That's like taking most productive days of the week.
Yeah.
All right, we're already past the half of the hour. We go out on a very short break, as we always would right here on Rapid On. And when we get back, we'll keep up with the conversation. Please stay with us. Welcome back, and thanks for staying with us. It's still Rapid Done right here on Rapid TV, and we have been having conversations centered around the sentence of Mazi Nnamdi Kanu. We have had the pleasure of hosting Mr. Ibrahim Wali here.
Pleasure's all mine.
Yes. All right. Now let's go to the next question, which of course is the stand of a lot of Nigerians. Tensions are high, of course, and a lot of people would want to, you know, move for the motion of Nnamdi Kanu. Some people say, oh, let's not forget that this guy had caused a lot of harm to a lot of people. However, do you think that the federal government stance on this matter is driven by national security, or it is more about political optics?
Well, when you say the federal government, you know, that means a lot of things, right? You know, that consists of the National Assembly, the judiciary, the executive. So, right. So, but yeah, the matter was presented before the court at the end of the day, right? So that is, you know, the machinery. You might disagree with the court, you know, but the matter was presented before the court, and the federal government, or rather let's say the executive arm of government, obviously they are the prosecutors at the same time, but let's say the presidency, for example, they have maintained indifference so far. They have not said anything one way or the other. They have allowed the court process to progress naturally. So it's difficult, you know, to decide what the federal government position is, you know, but there are obviously advocates even in the House of Reps, even in the Senate, and the likes of Sowore, for example, who, you know, say that the federal government, the executive now, should grant clemency one way or the other, you know, and there are those who, you know, believe that he caused serious destruction. You know, there a lot of people actually died. Ms. Dora Queen, was it her husband, or was it?
Dora Queen died of an illness.
Not herself. I think her husband. You know, by these people. You know, the heads. There were a lot of killings. You know, police stations were actually shot. People actually died. People were killed. You know, and there was serious tension in the southeast. You know, there's still serious tension in the southeast. You know, so there are people who agree with the decision and say that, okay, we cannot condone these types of acts, right? So naturally it becomes political, especially because of the underlying cause, or the underlying, whether it's, you know, genuine, whether it's motivated by, but the underlying cause is self-determination. And Nigeria, we have a history with, you know, the advocacy, or rather the even war for self-determination. So it's naturally political. You cannot remove the political aspects from it. So it's not easy for either of the parties involved, to be frank. Even the federal government, I'm an ardent critic of the federal government, but it's really difficult for them to decide one way or the other.
When you say it's really difficult for them to decide, this is probably where I'm going to cut you, because we have claimed that, part of the judgment claims that he has caused a lot of havoc here and there. And we're talking about extremists now, because whether we like it or not, as long as the IPOP has been proscribed as a terrorist group, you know, it's because of the violent and extremist ideology behind the entire movement. But we also see that there are same extremist ideology and movement here in Nigeria, perpetrated by certain key political religious leaders. I'll give you an example. We're talking about Deborah, and I'm sure that when that judgment was passed, you must have seen most of the comments that were passed about Deborah, that Christian girl who happened to make a comment in a class group. Exactly. And we had over 30 senior advocates of Nigeria support those people who were charged.
They did?
Yes, they said, yes, they said they were senior advocates. You know, some of the, what they call it, some of the allegations to that story says there were advocates, people advocating for the release of those people. You know, people who also carried out extremist activities. We're talking about the Boko Haram now. You know, there are certain names that have been released that have not been acted upon. In fact, someone from the government talking about we need a lot of resources. It's not a matter that we need to rush. We need to take our time before we prosecute such a matter. And then there's one on the other hand where such a judgment is being passed. And I think at this point, Nigerians are at a very sensitive position, not just to support Nnamdi Kanu now, but looking as judgment is, I don't know the right words. I'm trying to get the right words to use, but selective justice. That's what I'll call it. Selective justice, where one person is held accountable for his fault and for his offenses and for all of the crimes that he has committed, but another person is not held accountable. They are let to walk freely. How do you think that Nigerians are supposed to interpret this, and what do you think that, where do you think that this places the Nigerian rule of law?
Well, first of all, this is precisely why I really, can't come out and disagree with anybody who holds a particular position regarding Nnamdi Kanu's judgment, frankly, because of these other instances. But first of all, it has to be said, and we have to remind ourselves that what happened with Deborah is highly condemnable. It's condemnable. It was sad, and it's unfortunate that the perpetrators, even though they were caught on camera, are actually still breathing today. I think that they should have been really executed by now, through the process. Yes. I'm surprised that you said 30.
Yeah, you should see some of the,
I think I had 50 lawyers, senior lawyers, but I didn't know that 30 SNs is quite a lot. Maybe we should, yes, but probably quite a lot of lawyers. And, well, it is a dilemma because everybody deserves representation at the end of the day. But representation does not mean, trampling on justice.
Absolutely.
Both the defense counsel and the prosecution, are by law, servants of justice, servants of the court. So as a defense counsel, yes, you want to get your clients off, but you do it by, ensuring that he really did not commit the offense and that they are not convicting him for, an offense that he did not commit. So they deserve representation all the same, but I don't see how they are still alive currently. So obviously that is a blight in our justice system. And I think even outside of these cases, reality is inequality in our justice system. So this is not just an isolated event, but obviously this brings it to that primacy, that limelight. But our justice system is really, really, unfortunately, disproportionate in that regard.
Administration of justice.
Yes, bandits. I mean, my heart's ache, when I talk about it, because I'm from Niger State, right, and they have taken over an entire 1/3 of the states, and it's not even making headlines, right? And the saddest part is, it's not even about prosecuting the bandits themselves, but they have an economy, they have an entire network.
Yeah.
The governor of Katsina State came out and said that a community leader accepted 700,000 naira, and to allow attacks to happen, but we have not heard of him being taken to court, prosecuted, and punished. They are having so-called peace talks in Katsina with bandits, and they come with
attending their events,
RPGs, and all of that. We have not seen any major prosecution. Obviously, they prosecuted some guys recently, Mahmouda, and so there's that. But yes, so that's why it's very difficult to disagree with those who. But the reality is, if they go through the process, because we cannot complete these issues if they go through the process, they go through the Court of Appeal and Supreme Court, and they find that he indeed did those things and they led to those disasters, then it will be, I think that we would just, we will be backtracking by saying, because we were not able to arrest and prosecute these persons, and we should be let go. Then it means that, the implication for the rule of law, then it means that we don't have a rule of law. But the reality is, we may not have a rule of law.
Exactly, because that's why people call it political now.
Exactly. And, and to an extent, you also understand that Nigerians have lost trust in the justice system.
Absolutely.
And that is something, you're a lawyer anyway, that's something that your profession needs to help Nigerians actually regain as it is. But again, going back to Nnamdi Kanu's case, we see that Justice Omotosho actually labeled Nnamdi Kanu as an international terrorist, based on some of the comments that he made against the U.S. Embassy, the British, and all of that. Now, what is the legal significance of labeling someone an international terrorist in a domestic court?
Well, first of all, that is an obiter. It's just an opinion of the court.
Yeah.
It's not a ratio decidendi. It does not apply. It's just what the court feels like, because there's no charge before the court that tries to punish him or tries to charge him with regards to international terrorism, right? So it is just in the evidence, in his proclamations that the court picked this. The court is allowed to reference obiters and everything. So, but this is an obiter dictum. It does not make him it does not certify him as an international terrorist, at least not by Nigerian law, because obviously our judgments are law, so it's not as if that is the law. So, but there are parameters to, deciding that one is an international terrorist, so there must be cross-border operations, and there are conventions that outline, the conditions, and I don't think that with Nnamdi Kanu, it suffices, or at least it has not been proven, or it has not been taken up, and expanded. So I don't think that the courts meant that this is
exactly that. He has a UK citizenship. Do you think that the UK government has taken enough stance in this matter? Because it seems like they're really quiet. We know that in Nigeria, in a case where their citizen, let's say their actual citizens, happen to be in distress or in any matter like this, you see their proactivity. They come out, they speak for their citizens. Sometimes they try to do negotiations where they ask that these people go back to their home country to face the centers. We have been asking for Ekweremadu for a while now. We haven't gotten any response as of that right now. But he is a UK citizen. Do you think that the UK has taken enough posture or enough stance on this matter?
Quite frankly, obviously I can't speak for the UK, and quite frankly I have not followed their perspective or otherwise on the matter. But he is also a Nigerian citizen, so he's competent to stand before the court. I don't think that there's much the UK can do in that regard. Maybe through diplomatic means, but then there's limits to it, and there's limits to how much they can interfere as well. And maybe they are not exactly sympathetic to his cause, or they probably
they don't care.
I mean, I don't see why they really should anyway.
So what are now the realistic legal options now that Nnamdi Kanu has? What are the stands that his legal team will be using to maybe do an appeal?
If he has a legal team, that is.
If he does have a legal team now.
I'm sure you should be advised to set one up by this time, because he has seen, because I saw him cry in court. In fact, that picture was a meme for a long time over the weekend, where people were saying this should be an example of everyone who wants to perpetrate violence and I'm like, that's not a clear example. This one, anyone who wants to partake in terrorist activities, it doesn't make any sense. Do they even care? They don't
care about that judgment whatsoever. I mean, left to them, Yes, but yes, I think I've mentioned quite some grounds that they can, there are quite a lot of grounds, but if I say I want to go into details, they will think I'm unapologetic. But I'm a lawyer, and I see things from that perspective. When I look at the judgment, I really don't see Nnamdi Kanu or Justice Omotosho. I just see facts and positions and issues, and so that is my analysis, and I really advise them to go on appeal. Because I also want to see what the Court of Appeal would say. Really. I believe that their jurisprudence is a lot more expanded. They have more room to go into the issues underneath. The trial courts, cannot deviate much and go into issue of secession, issue of this. But with the Court of Appeal, they have that, especially the Supreme Court anyway, they have that leeway to really, and even clarify this international terrorism position. I'm sure that they can either, disagree with the lower court or agree and expand it and statewide. So I think that, the next course of action should really be to test it at the appellate courts. I think that is what every reasonable mind should anticipate or should promote. Let us put it forth, because let us at least let's put it through the process, so that at the end of the day, whatever decision is taken, we are clear about the parameters.
I was asking Alokutus, even after that, you want them to appeal because they gave him an opportunity to plead for mercy.
Yeah, but appeal is not a plea for mercy.
It's not a plea for mercy. Okay, it's a disagreement. Okay.
Yeah, so it's a review. So an Alokutus is the right that is given to all defendants, not just Nnamdi Kanu. All defendants, by the time the court has convicted you before your sentencing, they give you an opportunity to plead. But
to reduce your sentence, does that reduce your sentence?
It depends. There are certain sentences that are mandatory. Okay. There are certain sentences that have high and low thresholds. Maybe they would say 25 years, but you can give 15 years. So it is within those possibilities that your allocators might hold any weight. So it's not as if there is a mandatory punishment Yeah, you can bring your village people, your grandmother, and everybody to help you.
Well,
but can't do anything.
yes, if there's one thing we have spoken about is the fact that, you know, everyone literally wants the case to come to an end at this point because it's lingered for so long. Nnamdi Kanu this, that, and that. Even it got even worse when we heard that he had been moved from Kuje Correctional Facility to the Sokoto one, and his wife was like, I haven't heard anything. Nobody told me anything about it. She just came online to see the updates on that story, which I think is also very unfortunate. Because
have we had any official reports on that?
No official reports, but you know, a lot of people.
Whereabouts should be, especially to his family.
Exactly, should be known, and I think it's very unfortunate for such a person to come online to find that, you know, without being properly communicated to her.
I think, okay, you know, just to be, you know, on the side of the court a bit. I think the court thinks that, okay, if you are convicted for incitement, if you have that type of loud voice, maybe your visitations should be a bit
very limited.
Maybe.
Well, the whole thing,
because you can still, I don't know, if his voice is that potent, then he can really still do, you know.
I like how you said if it is that potent. But I personally am looking forward to what is going to happen in the Southeast. This judgment has been made. Is the seat at home going to come to an end? The unrest that we have seen in the Southeast that has lingered for a very long time, is that also going to come to an end? Because it's assumed that we have gotten hold of the problem, we have sentenced the problem, then it should come to an end. If it doesn't come to an end, then that I think that's one of the fairest ground to even go ahead to appeal that judgment, because you claim I'm the problem. Now you have held me, but more problem is still erupting from the Southeast. What do you have to say about that?
Well, just like our legal guest has actually said, let's just keep our fingers crossed to see what the appeal is going to look like. Is the sentence going to be reduced, or is it going to be upheld just like the court has made it look? But let's see how that plays out. Just
one more thing, especially in regards to this sit at home. It is the government's failure completely.
Not Nnamdi Kanu.
That's,
you know,
because how can one man hold the entire state to ransom?
This is government failure, 100%. It means government has no control of its so-called territory. It has no control of, you know, its activities. You know, so this is on the government. This is it at home.
He had to say it.
If it continues, in fact, the fact that it has happened initially, in fact, it's on the government. It means that they cannot, you know, do their jobs.
Absolutely.
So regardless of the judgment.
All right. This brings us to the very end of the conversation surrounding the entire controversy and judgment of Mazi Nnamdi Kanu. Thank you so much, Ibrahim Usman Wali, founder at Wali Law Firm. Thank you so much for joining us on the show today.
Thank you very much.
Of course, we're heading out right now, and to end the conversation, we'll remind you that we're active across social media platforms, on Facebook, on Instagram, on Twitter, and on X. On Twitter. X is Twitter. Okay. And on Instagram, it is at Rapid TV. On YouTube, it is at official Rapid TV. And on the website, it is www.rbnradiotv.com. My name is Martha Alu.
And my name is Victor. Okay. See you tomorrow.
See you tomorrow.